Hello, everybody. I'm going to be discussing today something that's near and dear to the hearts of many people in California and some of our clients who are involved in it, and that is the issue of piercing the corporate veil. We're involved in one case right now where there's about $250,000 at stake, and the opposing party got a judgment on a lease that wasn't paid, and our client is a CEO of the company, although he was really not an existent CEO in the sense that he became a CEO as a favor to a friend in order to help in some biomedical research projects. And regrettably, his friend bailed on this whole situation, it seems, and now he's stuck in a lawsuit where under Section 187 of the Code of Civil Procedure, they're trying to bring him in as a judgment debtor after the trial, meaning once they have a trial and they have a judgment, then they want to add someone else who can pay it if they're unsuccessful in obtaining the fees from one person. And part of the theory that they're using is they're trying to pierce the corporate veil, meaning that even though the company was a corporation, if you can prove certain things existed, you can then wipe out the protections that a California corporation offers you, and you're held naked to all kinds of liabilities. Then we're involved in another case where I think 3 days ago, the lawyer on the other side came up with the idea of not only suing my client's company, but also suing him personally because he's a small corporation, one person, and stating that there is no separation between church and state, as you will, or if you will, and that really he was not a corporation in doing business, therefore they can pursue all of his personal assets. Don't worry, we'll win in both cases, but I want to take the time. I thought this was a good time to explain to you some of the concepts behind these issues, because we just ended up conducting so much research in this area. So let's start with what they call the alter ego doctrine, where they basically state that the corporation is really you, and you're the corporation, and you create something, but in reality, it's not its own entity. It's just an alter ego of you. And they must demonstrate that the two of you are one and the same, so that if that happens, all of the corporate protections are removed. Unlike an LLC, a corporation is much stricter when it comes to the annual meeting that you have to have, keeping records, the minutes of the meeting, separate bank accounts, commingling. Now, don't get me wrong, a lot of these same principles are in effect with an LLC, but with a corporation, they're more rigidly enforced. And so let's look at the factors that are examined if you're involved in a case like this. Now, first of all, not having your annual meeting is a big no-no. Not paying your fees. We were involved in a case, lovely for my clients, in the sense that the opposing side chose not to pay their $800 annual franchise tax fee. Guess what? No corporate protection whatsoever, so you have to go after them individually, which of course forces people to settle much quicker than if it's under a corporate entity. And I believe in settling cases rather than fighting them out anyway. But let's look at some of the issues. Apart from the annual meeting, commingling of funds and other assets. This is the same problem that clients have in family law issues, where you commingle meaning you kind of mix up together to where you can't separate one person's money from the other. That happens in family law issues, and it happens in piercing the corporate veil issues, where if your money is mixed up with the corporate money, or let's say that you use your personal credit card to pay corporate bills or vice versa, and the lack of segregation of the funds is one indicator of the possibility that it's an alter ego. It doesn't definitely show it, because There are times that all of us are caught in a situation, as I was actually yesterday at a, what do you call it, I went to a fundraiser, charity event, and they were actually, they had in their silent auction a wonderful package of marketing assistance. And in one of our programs that we're developing, we wanted to use a marketing professional. And I happened only to have my personal credit card, so it was a Saturday night, and I bought it. And the company can compensate me back as long as I keep accurate books. So it's considered a temporary loan. Obviously, it'll be paid back in a week. But, that's going to happen occasionally. But if it happens regularly to where, it's 50-50, for example, half of the expenses on my personal credit card are company expenses, then it doesn't look too much like me treating the company like a company, but really an extension of myself. And that is where you get in trouble. Now, another indicator is the treatment by an individual of the assets of the corporation as if it were the individual's own. That's where you have to be careful. For example, let's say you have a company vehicle and it's used for whatever it is that you do, and but you're using it 24 hours a day, use it for personal items, use it for company items, or especially if it's your only vehicle, then you have a problem because, again, that's another indicator. Third one, the failure to obtain authority to issue stock or to subscribe to or issue the same. If you've got a board of directors and you don't use them and you just decide, oh, I'm going to do this today, going to do that today, you've got a problem. You're better off simply having a corporation without a board of directors, without other people who are responsible to you. If it's your company, you own 100% of the shares, make the decision and execute. But if you have people in charge of things, like a treasurer in charge of the money, and it's not you, you need to go through that person. Now, another one, the failure to maintain minutes or adequate corporate records and the confusion of the records. This happens so often with my clients. They really, really have to be careful because that's just the first thing they'll nail you on. Another one is the holding out by an individual that he or she is personally liable for the debts of the corporation. If it's a corporation, it has its own debts. Now, for example, in some situations, let's say you're procuring real estate, you're getting a lease on some commercial property, some office space for your corporation, and you're a relatively new or unknown corporation. They're going to want you to personally guarantee it, but the main lease should be in the name of the corporation. And everybody knows how businesses run, and they know that you have to personally guarantee it. But if you're out there personally guaranteeing everything, then you're not much of a corporation, because it's hard to say where the corporation begins and where that relationship ends. Let's have a look at some other indicators so that you can protect yourself. You're going to like some of these. Whole list of them for you. I won't go through all of them. I'll give you as many as I can that make sense. The failure to adequately capitalize a corporation. That's quite a popular one. Some people, all the money that they make in the corporation, they end up pulling it out at the end of the month. No, it has to have its own capitalization, as it's called. It has to have its own money, enough to run in case sales are low or something happens. So that's actually a big and popular one. If you employ the same employees, let's say you own two companies, one's a corporation, one isn't. You have the same employees, same attorneys for yourself and your corporation, et cetera, et cetera. Again, it's hard to distinguish the two, and that's where you have a problem. The use of the same office space or business location, that's another one. Sole ownership of all the stock by one individual or the members of a family. Now, there's nothing wrong with doing that. The problem is when you add up all the other indicators. So really, somebody has to paint a picture. It's not just any one that necessarily states that it's an alter ego. It's how many you have and how they interplay. Identification of the directors and officers of the two entities in the responsible supervision and management. If you have the higher level people, as I mentioned before, identify who they are and have them do that. Treasurer is in charge of money. Money issues, go through treasurer. Treasurer should know who your big bookkeepers are, who your CPAs are, and should be aware of the finances of the company. What else? Total absence of corporate assets. And that also goes with the undercapitalization one. If everything that you buy for the company, for example, computers, desks, car, you buy all these for your corporation, are all under your name, what does it look like? It looks like you're just going to run the corporation, someday probably bankrupt it out, and not really worry about it because all the assets are in your name anyway. That's a huge no-no. The use of a corporation as a mere shell, instrumentality, or conduit for a single venture or the business of one person. Well, of course, that goes without saying. The concealment and misrepresentation of the identity of the responsible ownership, management, and financial interest, or concealment of personal business activities. If there's anything that you do that can make it look less than clean, for lack of a better word, or that would give any person any doubt, always record in writing, date it, sign it, maybe even have somebody witness your signature that happened on that day that you signed that, and explain the situation, because all it takes is a couple of things that don't look right, and then all of a sudden people with their imagination can create something that wasn't there. The disregard of legal formalities and the failure to maintain arm's length relationship amongst related entities. Again, legal formalities such as having that meeting, that one keeps coming up. But again, anything, let's say that you're loaning $10,000 to the corporation. There should be a note, a promissory note. Write it up, sign it up. Corporation owes you X amount of money. The use of the corporate entity to procure labor, services, or merchandise for another person or entity. The corporation that you have should only be doing things that the corporation does and nothing else. So it should be representing its own interests. It shouldn't be helping out your friends, your companies, or you. The diversion of assets from a corporation buyer to a stockholder or another person to the detriment of the creditors. That's obviously a big no-no, because you're not here to hurt the creditors of the corporation, and it's not meant for that role. The manipulation of assets and liabilities between entities so as to concentrate the assets in one and the liabilities in the other. It's kind of along the lines of what we discussed a few moments ago. The contracting with an intent to avoid performance by use of a corporate entity as a shield against personal liability, or use of a corporation as a subterfuge for illegal transactions. That basically goes without saying. But the first part, if you didn't understand it, you sign a contract, somebody pays you a lot of money, you don't intend to do what it is that you stated that you do, you keep the money anyway, then you file bankruptcy when you get sued and you just made some money. Not allowed. And the formation and use of a corporation to transfer to it the existing liability of another person or entity. So let's say you're running your own company, it's not doing very well, and then you create a corporation and you transfer the debt to that corporation. All of a sudden, you're cleared debt, the corporation has it all, and you can BK the corporation. Not going to work. And that's basically all I wanted to share with you today on this. There's no other way to put it other than these are two separate entities. Treat them as two separate entities, and you'll have no problems whatsoever. The minute you start mingling together, and again, you really have to take this seriously. Keep the books separate. You're loaning company money to the corporation. Write it down. Make a note of it, etc., etc. Don't have money flow back and forth without explanation. And then you should be fine. Then you'll have all the protections that a corporation allows you to have. But otherwise, if you're in a lawsuit, one of the first things a good lawyer will seek to do is what's called